I'm gonna make you host, and then you'll be able to make Jessica co-host once she jumps on.
All right, sounds good.
Awesome.
Doing anything good for vacation day?
Well, it's a Jewish holiday, so I was like, might as well take off because I haven't taken any days off during COVID yet. So
I gotcha. I hear you.
definitely nice to take time off. I'm not planning on doing anything big, but just spending the weekend dipping apples in honey all weekend.
Oh, nice. Getting ready for fall.
Yeah. Alrighty, I'm gonna go. So when someone joins the room, it'll tell you person's waiting in the waiting room,
Mm-hmm.
and then you just have to admit them.
All right, sounds good.
Awesome, thank you.
Of course, my pleasure.
Bye.
Nice talking to you. So, hi everyone. So it's noon now. Going to give it a few more minutes and let some more people come in and start around maybe 12:05.
Alyssa, can you see my screen?
I cannot. Maybe I should try making you the only host instead of
Oh,
co.
you know what? I didn't click share, so that's probably why.
Okay. Yeah, I can see it now.
Okay, great. And can you see the slides moving?
Yep, I can see him moving.
Okay, great. I'll leave it here for the recap.
Okay. All right, so it's 12:05. We'll go ahead and get started now. My name is Alyssa Villarreal, and I'm here with my colleague, Jess Penkoff. We are, I know some of you were here for our presentation on Wednesday, but for those of you who weren't there and are joining us for the first time, we are staff attorneys at a not-for-profit legal services organization called Volunteers of Legal Service, and we work in the elderly project. Our primary focus in this project is helping seniors obtain their life planning documents, and we're going to talk about two of those documents today. On Wednesday, we spoke about documents that are in effect during our lifetimes, which included the healthcare proxy, the living will, and the power of attorney. And today we're going to talk about documents that kick into effect once we've passed away, which include the last will and testament and the appointment of agent to control disposition of remains, which is a mouthful, so we just shorten that to control of remains form. So before we start on that, just to note that the documents we spoke about last time, the medical advance directives and the power of attorney, those die when we die. So once we pass, those documents are no longer valid. And the ones we're talking about today, those are the ones that are going to go into effect. So I'm going to start with the last will and testament. And the will is probably the document out of all the ones we're talking about that people have heard of the most frequently. It's a document where you're writing out instructions for what you want to happen to your estate once you pass. And your estate is everything you own at the time of your death. So it includes your money, it includes your furniture and the other contents of your home. It includes your beloved pet cat, everything that you own when you pass away. So in your last will and testament, at the beginning, it typically says that I, your name, and being of sound mind and memory, declare this to be my last will and testament. And it's a good idea to note in the will who all of your immediate family members are, as well as their addresses. And this is because once your will is submitted to court upon your passing, all of your immediate family members are going to be required to be put on notice that this is happening, and it's going to be on written notice. So it can be very helpful to include that information right in the will. So in terms of how you want to distribute your estate and how that gets written out in the will, you can one, list out specific items of your property and say to whom you want it to go, such as I give my class ring to my daughter, I give all of my family photographs to my granddaughter. You can also name, in addition to those, we would call them beneficiaries, the people who are taking your property. You can name alternate beneficiaries as well, and that's in the event that a beneficiary predeceases you, which means passes before you do. So to go off that first example, I leave my class ring to my daughter, you can also say, if my daughter predeceases me, then I leave my class ring to, say, my son. And you can also have multiple beneficiaries for the same thing. Going off the second example, instead of just having your photographs, say, go to your granddaughter, You can say, I give all of my photographs to all of my grandchildren to be divided among them as they see fit. And after you name out any of those specific items that you want to give away to certain people, if you have any, you can also say where you want just the general contents of your apartment to go, like your furniture, your clothing, anything else that might be in your apartment. And then after that, this is a clause that's going to happen in your will that happens in every will called a residuary clause. And that just means anything that wasn't already previously covered in your will, which might be, cash that you have inside of your apartment, or really anything that's just not otherwise specifically noted in your will. And there are also important provisions that should be included in wills as well. One provision that we include in wills is to make sure that if any of your beneficiaries at the time of your death happen to be disabled and receiving means-tested government benefits, such as SSI, Supplemental Security Income, that this doesn't affect their benefits. So for example, SSI, if a beneficiary is receiving that at the time of your death, that has very strict income and asset limitations. I think in the year 2020, if you're on SSI, you're only permitted to have, I think it's less than $2,000 in assets. And even if you go $1 above that limit, that can get you kicked off SSI, and that can just cause such a huge burden. So we include this provision to make sure that the money is handled in a certain kind of special way, rather than just, say, having a check cut out to that beneficiary, which could wind up hurting them, that it basically just gets taken care of in a different way, such that it's legally hidden from the government's eyes. And let's see, what else is included in the will? You can also appoint, and you don't have to, but if you do have someone in mind or someone's in mind to serve as what's called the executor or executors of your will. And this means someone who is in charge of following the instructions in your will. So this would be the person who, when you pass, they take your original last will and testament, because the original will is generally the only thing that's going to be accepted by the court, not copies. They bring that to the court along with your death certificate, and they submit it and petition to have it admitted. And they also petition to become that executor, and the court has to approve them as executor. So just because you name this person to be your executor doesn't necessarily mean that the court will approve them. It does have certain restrictions. For example, if your executor has been convicted of a felony, the court won't permit them to serve as executor. And you can appoint more than one person to do this job. In that case, they would be called co-executors. You can also appoint a backup or backups for executors in case your main executor is unable or unwilling to do this job. And like I said, you don't need to have anyone in your life who you think that you could name in this role. There is a part of the courts that's called the public administrator, and it's the public administrator's job to handle estates that otherwise don't have anyone else to handle them. So your will can still be submitted to the court, and that public administrator can be the one who follows the instructions in your will and gives everything to your beneficiaries. So at the ends of the will, or towards the ends of the will, is a section for you to sign. And after that section is a place for two witnesses to sign, because a will needs to be signed in front of two witnesses. Typically, the way that this would go, pre-pandemic at least, is that you would sit down face-to-face with an attorney, and they would ask you a series of questions that are very basic. It oftentimes makes people feel like they're being treated like a child, but everyone needs to be asked the same set of questions. And how that conversation would go is, if I were your attorney, I would put the document in front of you and say, do you know what this document is? And hopefully you would say, yes, it's my last will and testament. And I would ask, have you read this will? And you would hopefully say yes. And I would ask, does it reflect your wishes? And hopefully you would say yes. And then I would point to the two witnesses who are in the room, and I'd ask, do you wish for these two people here to serve as witnesses to your will? And hopefully you'd say yes. And then you'd be able to put pen to paper and sign the will. And then the two witnesses would also sign the will. And typically there would be a special affidavit that comes after the will called an affidavit of attesting witnesses. And the witnesses would also sign that page. It would have to be done in front of a notary. And typically there's always a notary in the room. If you're in front of me, I would be serving as the notary. And this might seem redundant that they're like witnessing your will twice, but this special affidavit adds a measure of security for when your will goes to the court, because it's the witnesses essentially saying, yes, I am the person who witnessed this person's will, and I am swearing to that. It's not necessary to have this special affidavit at the end of the will, but it makes the process of your will going through court a lot smoother. Nowadays, the process looks a little bit different. The last presentation, we talked about how virtual executions look. And the way that would go is you would just be holding up your will to the screen and just saying the answers to those questions you would otherwise be relaying to me. Like, this is my will, I have read it, it reflects my wishes. And then there would be a whole back and forth of signing and scanning and printing between all of the witnesses. What to do after you've done your will is important. Your will should have been stapled before you sign it. Once you sign it, don't remove those staples, because things can become very problematic if you remove those staples. So what would happen if that does happen is when your executor brings your will to court to submit it, they would have to complete an affidavit of unstapling that would be given to them by the court that would state how this will became unstapled, and the court may or may not still accept that will. And the reasoning behind this is that if a court sees a will has been unstapled, they might think, oh no, somebody could have taken out a page of the will and reinserted a different page that was more favorable to them. So we need to make sure nothing like that happens. So it's a measure of protection for you and your wishes. Like I said before, the original last will and testament is generally the only thing that's going to be accepted by the court. They generally don't accept copies. Only in super rare circumstances will they accept copies, and that's in situations where, you know, it's very likely that the will could have been destroyed through no fault of you. One example is, say, if you happen to live in the far Rockaways when Hurricane Sandy hit, your home got destroyed, you passed away a few months later without a chance to do a new last will and testament in case that one got destroyed. In that case, the court might consider a copy of a last will and testament just because of that extreme situation, but generally that doesn't happen. And once you've done your original will, you should store it in a safe place. You can either retain it for yourself or you can give it to your executor, because your executor is the one who's going to need to use it once you pass. Do not put it in a safe deposit box though, because this can cause another big problem. And I know a lot of people who have put their original wills in a safe deposit box, and that's not a good idea because once you pass, your bank gets notified of your passing, and that safe deposit box will automatically get sealed. And your executor isn't allowed to go in and get that will without going through a special department of the court, just called the miscellaneous department. Basically deals with things that get sealed, like boxes and apartments. And they'd have to fill out a petition to have that box unsealed so that they could retrieve the will. And it's a whole long process. It really delays things, and your executor already has a big job to do. They're already going through a lot after you've passed, and this is just something that could cause a big problem for them. And it's easier if everything is handed to them on a silver platter so that everything goes smoothly. But it is a good idea to have copies of the will regardless. Just make sure that when you're making copies of the will, don't remove those staples, because it can be kind of intuitive to remove the staple, send things through a scanner, and then restaple it. And it's kind of a pain to make copies of an original last will and testament because you have to fold over everything very carefully so that you can still see all of the text on the page, and then put things all together once you've done it. So if we don't do a will, what happens to our estate once we pass? So instead of the instructions of your will being followed, if your estate still needs to be handled when you pass, your estate will pass via a set of rules that's set forth by New York law. And the way that things will go is going to depend on who you leave behind. So for example, if you leave behind a spouse and no children, everything's going to go to your spouse. If you leave behind a spouse and 2 children, your spouse is going to get a certain amount. I think it's $30,000 plus half of the rest of your estate. I might be off with the numbers there. And then your 2 kids would split the remainder. And it has a whole list of different scenarios based off of who you leave behind. And it ends somewhere at like second cousins. So you won't have any choice in terms of who gets what, who gets how much. That would be dictated by the law. You wouldn't have any choice in who is allowed to follow the instructions of the law and distribute all of your stuff. The law sets forth a hierarchical list, which is pretty much, it looks pretty much the same as the hierarchical list that Jess mentioned with the healthcare proxy. If we don't do that, who's allowed to make decisions for us? It starts with the spouse and adult children, if you have adult children, parents, siblings, then it goes a little bit further into other family members. So let's see, what else do I want to note on the will? I think that's pretty much it that I have for the will. So I'm going to turn it over to Jess now to talk about our control of remains form.
Okay, thanks, Alyssa. And I also just wanted to note, a lot of people have mentioned that this is a lot of information and that It's a lot to take notes on. We don't hold you responsible for memorizing all of these details. Our goal is to give you an overview of what these documents are, what their function is, and how they work. But if you apply for services through our organization and we're able to place your case with a volunteer attorney, that attorney will reiterate all of this information to you. They'll make sure you're equipped with comprehensive instructions to be able to properly execute your documents. And they'll work with you over time, and you can ask them questions and they can explain things to you. So I just want to sort of alleviate any stress about writing everything that we're saying down. We will share this recording. We'll also share the PowerPoint. But if we place your case with a volunteer attorney, that attorney will, make sure that you understand all of these things that we're talking about, and you'll hear it all again at least once, if not many more times. So just want to put that out there, because I see a lot of people taking notes, which I love. I'm also a note taker, but I just don't want you guys to feel stressed by the amount of information, because I know it's a lot. So, so this is the last document that we're going to talk about. The official name of this document is the Appointment of Agent to Control Disposition of Remains. We simply refer to it as the Control of Remains form. So this is a pretty short form. In this form, you're going to name an agent who is going to be responsible for making sure that whatever you want to have happen to your bodily remains after you pass away is in fact what happens. So in this document, you will provide the name, address, and phone number of who you want to be your agent. That person can also be the same person that's your executor and your healthcare proxy. You can name the same person in all of these documents if you want to, and a lot of our clients do that. It tends to simplify things to have one person in charge. So in addition to providing the name and contact information of your agents, this document very clearly states what you want to happen to your remains. So you can say, I want to be cremated and I want my ashes scattered, in XYZ location. Or you can say, I want to be buried. You can say, I want to be donated, or I only want certain parts of me to be donated and the rest of me to be cremated. Whatever you want to have happen to your remains, you will lay out in this document. Another thing to note about this document is that if you have already arranged for your funeral, if you've already paid for your burial plot and made arrangements on that front, then you can indicate that in the Control of Remains form. And you can actually appoint the funeral home as your agent. If you don't have an arrangement like that already, if you haven't already paid for your burial or whatever the case may be, then you just indicate that in the form. And your agent's ability to carry out your wishes will depend on if there's enough money left in your estate. So if you say you want to be buried and you haven't already prepared for that financially, then your executor is directed to pay for your burial and funeral expenses out of your estate even before monetary gifts go to anywhere else. So if you have the means and you want to, you can arrange for things before you pass away. And if you don't, just know that that your agent can do what you're directing them to do to the extent that there's money available in your estate for that purpose. So sort of like the healthcare proxy, you can only name one agent. You cannot have two people. It just becomes logistically complicated, and you really only need one person to handle this stuff for you anyways. You can also name a successor agent. So an agent that is going to step into or someone that's going to step into the agent role if the person that you chose originally is not available to do that. This document does not come into play until after you pass away. So you sign the document before you pass away. Your agent signs the document after you pass away. So for this reason, we would recommend giving this document to your agent so that once you pass away, they can sign it, and then they will be enabled to act on your behalf with respect to your wishes. As always, we want to talk about what would happen if you didn't have a control of remains form when you pass away. So what will happen is there's a statute called the New York Public Health Law that says if you don't have a control of remains form, then there's a hierarchical list, as always, of people that will be authorized to handle this kind of thing for you. And it starts with your spouse if you have one. If no spouse, then it's your children. If no children, your parents, and sort of goes down and out to the branches of your family members from there. And it's a very short form with a long name. Like we said, it sounds a lot more daunting than it actually is. And so don't be put off by the name. And if you hear us say appointment of agent to control disposition of remains, if you hear us say AACDR, if you hear us say control of remains, we're all talking about the same form. So regarding that public health law, just like with the healthcare proxy, the default here, the public health law, it might do what you want to do anyways, but it also might not. So the public health law might say that so-and-so is the one that gets to make these decisions, and so-and-so might not be the person that you want doing that. So, we're here to enable you all to express and carry out your wishes. And we think that having a control of remains form is really the best way to make sure that your wishes with respect to your bodily remains are followed. I do also want to note about things like donation and scattering your ashes, that you should look into whether or not, well, let's start with donation. If you say you want your body to be donated or some of your organs to be donated, really the best thing is for you to specify where you want to be donated to, and if possible, provide like a specific information. So if you want your brain donated to a certain hospital, you can lay that out in the document. Before you do that, you should confirm with that hospital that they're accepting that kind of donation, because it's helpful for you to know whether or not that's actually going to be possible. If it's not going to be possible, you might want to make a different decision. We also have clients, like I said, who want their ashes scattered in a particular place. You should do your homework beforehand to find out if that's legal. There are a lot of rules about where you can and cannot scatter your ashes. So for instance, if you say you want your ashes scattered in the financial district in Manhattan, that's not possible. So you're going to want to make a different decision with respect to that, because your agent simply won't be able to carry that out. So just a plug for doing a little bit of homework, providing as much information as you can, and making sure that the things that you want to happen are actually legally and logistically possible. And I think that's all I have to say about the control of remains form. So I just want to give another recap here, because we weren't able to record the first half of this presentation. But on Wednesday, we talked about the documents that are important during your lifetime. That's the healthcare proxy, living will, and power of attorney. And then today we talked about the documents that are important after you pass away, which is the last will and testament and the control of remains form. So I am now going to put up the slide that has our contact information on it again, and I see that there's someone on the phone. And so I'm going to read my phone number, and then I'm going to read Alyssa's phone number for the folks that are on the phone. So my phone number is 347-521-5725. And Alyssa's phone number is 347-521-5709. And so we're going to share this PowerPoint with you all. We'll also ask Jenna, in addition to sending you all the PowerPoint, to send our intake form. So we serve, again, seniors and veterans that are age 60 plus that have low income and limited resources. So I would encourage you all to apply for our services, and the best way to do that is to fill out our intake form and send it to us. So again, I'll ask Gemma to email you all with our intake form, and you can just fill it out and send it to us directly. Another way to get that intake form is to go on our website at volsprobono.org/elderly, and you can download it from there. If you want to have a conversation with us first, if you have any questions, if you think you might not qualify, you're not sure, please give us a call. And if you do not qualify for free legal services from us, we are happy to provide referrals to private attorneys who practice in this area. Alyssa and I get asked a lot, how much does it cost to pay a private attorney for these documents? And my answer is always like, I have no idea. I've always been a free civil legal aid attorney. I've never charged my clients, and so I don't know how much this costs out in private attorney land. But we want to equip you with a few referrals so that you can shop around if you're not able to get our services for free. Okay, I think that's all I've got. So if you all have a question, you can unmute yourself and shout it out or put it in the chat box. We have, as much time, I think we have until 1 o'clock. So yeah, let us know if there's any questions, and we're happy to discuss that.
Will you send us a recording?
Yes, Gemma's going to share this recording with everyone on the list. So you should get it. And she confirmed with me the other day that, Yamina, that you are on the list. So you will receive a copy of it. I don't know how long it's going to take to prepare it. That's going to be on Gemma's end. But once it's ready to be sent, she's going to email it to everybody.
Okay, thank you very much.
No problem.
If you do not,
Go ahead, Carol, go ahead.
sorry, if you do not have a will and you are divorced, will your ex-spouse be entitled to some of your assets?
No.
Okay.
Okay.
Are you going to ask another one? Ask one, Gwen? If not, I have another question.
No, go ahead, go ahead.
Okay, now, if you don't have a lot of assets, is it still to your benefit to do a will?
Yeah, it can be. Some folks can get away with not having their estate taken care of through the court. Now, if there's not much to deal with, say if all family members agree on how they want things to be distributed, like they're okay with who gets what belonging. But I would still say yes, no matter how much you have in the way of assets. I think that you should still do a will to make sure that your wishes are going to be respected.
Okay, and the other question I have a son who's a little bit questionable. He's an adult, but I would want to set up a trust for him so that he would be able to pay rent and utilities after I pass. Can that be handled by the same attorney that handles the will?
So we don't do trusts because it doesn't apply to a lot of our clients, so we don't keep up to date on that stuff. I would say that they are rather expensive to set up. That's why it doesn't apply to a lot of our clients.
Okay.
But if you were to go through a private attorney, then the private attorney would be able to do your estate planning such that you could do a will and a trust set up for somebody who you think might not be able to manage their money so well.
Okay.
Okay, I have a question. I have stocks. So how would that play into my last will and testament?
So you can list out in your will who you want to receive those stocks once you pass.
Okay. All right. And let's say you had an account that you have forgotten to put a beneficiary. How does that work out in the last will and testament? Right, I'm thinking off the top of my head. I have a savings account and I have to go back and I don't think I named a beneficiary. So what happens with that account?
So if you don't name a beneficiary on an account at a financial institution, then it would pass through your estate and be taken care of through the court. And it depends on how your will is constructed. If you happen to have something in there that says, I give all of my money to X, or I give all of the contents of any and all of my bank accounts I may have at the time of my death, which would exclude anything that has a beneficiary on it, it would pass that way. If you don't have your will constructed in that way, then it would pass via that residuary clause that I mentioned, which takes care of anything in your estate that wasn't already specifically mentioned.
Okay, all right, thank you.
Any other questions while we're still on the line? And if not, then we'll wrap it up.
One last question, and I didn't want to dominate, but if you name more than one executor, will you still be given just one will, one original will?
Yep.
Okay.
So you can only have one original last will and testament at a time. Only one can be valid.
Okay. Thank you so much.
Of course.
It's a great help.
I'm glad.
Yes, this was very informational. Now I just have to be able to be considered low income, so I won't have to pay anything.
And for folks who don't qualify for our services, we do have a list of private attorneys who handle these matters. So if you contact us, we can provide you with that information.
Okay. Again, thank you so much.
You're very welcome.
Okay. You answered all my questions. I thank you very much for this. This was very, very informative. I mean,
Good.
so much to take in.
Yeah, it's a lot.
I know it's a lot of information.
Right. Just a last will and testament is not just that. It's such detail and explicit details and detailed details. Yeah. Thank you very much.
For sure.
I
Thank you very
actually
much
have
for
a
this.
last
I'm glad.
question. I have a last question, if possible.
Sure.
Yes?
Yeah, go
Hello?
ahead.
Yes. I don't have children, but I have siblings. Some of them passed away. So in order to leave my assets to all my siblings equally, is it possible to put, in case they die, like you say, per stirpus, right?
For stirpies? Yep, sure,
Yes.
you can say that.
So you can say that, so that if they are deceased, it goes to their children, correct?
Yep. Yep.
Okay.
So
And
New
that
York,
can be done in a will as well.
yes.
Okay, thank you.
Okay. So I think that is it for us. So thank you all for being here today and for being here on Wednesday and for being so participatory with us. It's nice to have such an engaged and active audience. So we really appreciate you all being here, and thank you for your time. And you should get an email from Gemma very shortly with the recording and the PowerPoint and our intake form. So if you don't get that, reach out to Gemma, reach out to us. But I anticipate that you should have that email early next week. Okay.
All right.
And that'll do it
Okay,
for
one
us.
very last question.
Sure.
And one very, very last question. I'm a procrastinator. In the event that I start a will and I happen to pass before it's finalized, what happens then?
Then your estate would pass via intestacy, which means that you pass without a will, so your stuff would be distributed according to New York law. So you have to have the will finalized and executed in order for it to be followed. It could still be used as guidance for your family in the event that all your family members agree on who gets what, and if your estate happens to not need to go through the court. But no, it won't be valid.
Okay. Okay, I'm good. Thank you.
All right. Thank you, everyone.
Thank
All
you.
right.
Bye.
Thank you so
Be
much.
safe. Take care.
Thank you. Thank
You're
you.
welcome. Bye, y'all.
Bye.
Bye.
Bye.